Hello, I'm Ken Bradley with AVR Properties. We manage rental homes in the Livermore Valley area. Frequently, people that have run into problems with managing their own homes will give us a call and see if we can't help them out. And that often means evicting the tenants. So I thought I'd cover the eviction process a little bit. There's several reasons why a tenant might have to be evicted. They might be damaging the property, not complying with the terms of the contract. They might not be paying rent. They may not have moved after being given appropriate notice to move, in which case then you need to go to the courts for relief. Before you do that, you need to look at your paperwork, your leases, your rent rosters. You need to make sure that you have all your stuff together, because during the process, if it goes to court, you're likely going to be challenged and actually be a defendant at one part of the trial. So hopefully you've done the things right. If you haven't, make sure you get them as right as you can before you proceed with the eviction procedure. Evictions start with a 3-day notice after non-payment of rent. So if you serve it on one day, you start counting the following day. And weekends and holidays don't count. So after the appropriate number of days to pay rent or quit, and it's a form that has to be correctly filled out, then you can either proceed to try it yourself, which is more than I'm going to cover here, or turn it over to an attorney. The attorneys will prepare a summons and complaint and hire a process server to serve the tenants to get them out. Now, if the process server can get personal service, the tenant only has 5 days to answer. If they don't get personal service, then they get 15 days to answer, and chances are they're going to dodge the process server. So plan on 15 days, at which time the attorney will press for the courts for a trial date. You should not be surprised if the tenant demands a jury trial. You shouldn't be surprised if they come up with an attorney paid for by the public, meaning you. And if you have attorney's fees in your contract and legal fees, attorneys are more likely to take their case to fight you, hoping they can get some money out of you. If it's non-payment of rent, the tenant may not have the money and not anything to risk, but you as an owner do. Before the trial, the tenant may file a bankruptcy. That shouldn't delay you too much. Proper attorney will file a relief of stay with the federal courts and proceed with the trial. It does change things a little bit and adds a little bit more time, but you can proceed. Once you have your judgment, and I'm skipping over a lot of things at the trial because you have to try and negotiate settlements before the judges will even hear the case. Once you get the judgment, then it's turned over to the sheriff and another fee, and the sheriff sets a date, and then you have to meet him at the house, probably with a locksmith, because they're not going to force their way into the house. They're going to knock on the door. If somebody answers, they'll proceed. If nobody answers, they expect the door to be opened for them. So that's where a locksmith comes in. Chances are pretty good that your key might not work. They may have changed the locks. At which time they're told to leave the property if they haven't moved out already. And hopefully if they've moved out, they've taken all their property with them, because if they haven't, you have to inventory it, store it for the appropriate length of time, and they have a right to come back, pay the storage fees, and get their items. If they don't come back and its value adds up to very much, then you're going to be forced to have a public auction. And hopefully you don't have to do that. So that's basically a 3-day notice. The first 3-day notice can be served by you. If you have a property manager like us, we serve it. We attempt to serve the persons named. We only have to get one of them. And if we can't get them, we do have to try. You can even try where they work. If you still can't get them, then if there's somebody else at the house sitter, it's an adult or something like that, you can serve them. It's called substitute service, and then you mail a copy of the 3-day notice. And if you can't get anybody after rigorously trying, then you do what's called nail and mail, and that's where you go out and you tape a copy of the notice to the front door, and you go back to your office and you mail it first class. Don't mail it certified mail. The law says first class. And of course you keep your copies for the attorneys and for the trial. So hopefully you never have to go through that. Most owners won't. That's why you do very rigorous screening of your tenants or applicants before they become your tenants. And you use real care in creating your documents of the lease and any violations of the lease that they have. For any of your property management needs in the Livermore Valley area, call AVR Properties.